The justices of the Appellate Division Court of Courtroom. Hear ye, hear ye, hear ye. All persons having business with the court of court will draw near, give their attendance, and they shall be heard.
Good morning, everyone. Please be seated. Anybody else coming? One of us. First case for our oral argument is 254, People versus Rodesia Anderson. Counselor, can you hear us?
Yes, Your Honor.
Very good. We can hear you. Mr. Hillary, good morning.
Good morning, Your
Are
Honor.
we ready to proceed?
May it please the court, Michael Hillary for the people. I'd just like to begin by underscoring a few points that are relevant to this about grand jury generally. Prosecutor is given wide discretion to present their case how they believe that they should and to present the kind of evidence they believe is necessary to do so. They have broad powers, they have broad duties.
But Counselor,
Yeah.
they also, don't they have a duty of fair dealings?
Most certainly do, Your Honor. Yep. I would only suggest, though, Your Honor, that there is a high bar for a defendant who would invalidate those proceedings, given the discretion that the prosecutor has. It's not a question of whether or not there was an error or two or even three. The question really comes down to, was the integrity impaired? Did the prosecutor commit misconduct, fraud? Was it pervasive? Was it willful? And
Was it prejudicial?
But that the defendant must show not just the potential for prejudice in that case, but the likelihood of actual prejudice. And I would suggest that in the circumstances that didn't happen here, and I'll begin with first of all, there were 2 points here that are of interest because the court decided this motion on 2 grounds: the justification, the lack of a justification charge, and the use of the certificate of conviction for the prior charge.
Why don't you discuss that first?
Absolutely. There is nothing in the statutory scheme that prohibits the people from approaching the charge the way that they did here.
Well, just so that I have a good understanding of the sections. The section here that the grand jury ended up indicting the defendant on, 26503 subsection 3. Principally, first thing that they need to determine is, was there a loaded firearm? Here, easy.
Yes.
Video, the gunshots. So that's not anything. And then but there's of course the exception that if it occurs in the person's home or place of business, well, then it doesn't apply. You can have a loaded firearm in your home or place of business, wouldn't violate this section of the law, right?
That's correct.
And here we also have pretty clearly that that's not the case. Was there ever an argument made or something that the defendant was using her car as her place of business, that she had is that something that was reasonable here, or was that possible? Because it seems that we need that before you get into then where you went next.
Yes, Your Honor. And to that point, it's the people's burden in presenting the charge to the grand jury to establish that the crime did not happen in the home or place of business. That would be our burden to prove before the grand jury. So here, just to be clear, the people bypassed that for what they conceived as the stronger proof, the easier way, perhaps, by establishing that there was a prior conviction, which would overcome the home or place of business exception.
So theoretically, just walk me through it, is that if the grand jurors start talking to each other and they say, oh, gee, how do we know? How do we know she's not working out of her car? It's not her home, but probably, but hopefully. But, how do we know she's not working out of her car? All of that. Then somebody would be able to pipe up from the back row and say, it doesn't matter, because even if this was her place of business, she has that conviction, and that now we fall under, the 26502 subdivision 1. And so then let's move on to the next charge. And that was the purpose.
I believe that was at least one of the purposes, yes. And it makes perfect sense.
But the thing is here, it just happens to be the prior conviction also is for possession of a weapon, which she's charged for now.
And I will not argue to this court, and I don't believe that the prosecutor that presented the case would suggest this either, that there was no prejudice. Every proof that we admit in a trial or in a grand jury proceeding is inherently prejudicial to some degree. What we're looking here is whether the prejudice was improper, whether it rose to a level that it impaired the integrity, it rendered the proceedings unreliable. And with the instruction that the prosecutor delivered here, which was that the jurors were not to consider that evidence for any propensity purpose. They were just to consider the evidence for whether the people met the elements of the charge. And there was no indication, and not only was there no indication the grand jurors wouldn't follow that charge, but they are presumed to follow an instruction by the
Counselor,
prosecutor.
are you familiar with any case law that prohibits a assistant DA or a DA to present to charge under this section because of the potential of prejudice?
I am not aware of any case that precludes us from operating. I looked and I can't say that there isn't one. I looked and I did not find one that prevents the prosecution as a matter of course from choosing this particular method to establish that charge in the grand jury, assuming all other things being equal, proper instructions, the proceedings are otherwise fair. I did not find a case that suggested to me that the people were outside of their domain to present it this way. So I think there are certainly cases that we can imagine where it's not entirely clear whether the defendant was in her home or place of business when the crime happened.
But that's not here.
It's not here, but it underscores the fact that prosecutors do need to have some latitude to make those determinations, which sometimes don't clarify until some time has passed. Sometimes it clarifies even beyond the grand jury. Not to say that happened here, but it underscores why prosecutors need to have some flexibility in presenting their case
So
generally.
it's your position that the prosecution has that prerogative to choose the path of how they're presenting the case.
Yes.
Do you want to go into justification argument?
Thank you, Your Honor. I would say that there was no reasonable view of the proof that was presented to support that there was a justification defense here. The defendant, no doubt, was assaulted here by this individual that presumably she was firing toward or at. She was assaulted, but she was able to extricate herself from the situation. She was able to get to her vehicle, get inside, and she pulled out of the lot. She enters the roadway. The person that had assaulted her is now back with the crowd near the store. As she's driving away, she looks over her shoulder out the window, almost 180 degrees the other direction, and fires shots into the crowd. This was a retaliatory act. We can probably understand the defendant's emotions here, as she was no doubt assaulted, no doubt hurt, probably felt all kinds of turmoil about what happened and what she'd like to see happen to the person that she was shooting at. But this is a criminal act. This was a retaliation with potentially lethal force, not only fired in the direction of Mr. Ziegler's son, but also toward a crowd that had no hand in any of this. And there was no indication under those circumstances that the defendant was prevented or impeded from leaving the scene. All she had to do was continue on and apply the gas, and she would have been completely out of harm's way. So I think there was just no basis here for justification.
Anything else?
No, thank you, Your Honor.
Very good. Thank you, Mr. Lewis. Counselor?
Good morning, Your Honors. Your Honors, I feel that the accumulation of all these factors and the court should consider all of them. If the court looks at the record around page 106, 107, the court asked about all of these other errors that are not addressed in the prosecution's appeal, such as the mugshot, the improper authentication of the video, which I think was recently hammered home in a court of appeals decision.
But in the decision, the court did not make reference to those other items, other than the justification and the charge.
That is correct, but in a grand jury analysis, it's always an accumulation of errors. Usually one error is not going to get you there. And the court certainly did consider the other errors. The court asked very challenging, specific questions about those errors.
Counselor, can I ask you the same question I asked your opponent about, is there a case that maybe it's not cited in your brief? I didn't see it. That talks about that the prosecutor should not be using this particular section 265.033. I mean, it's a legislative scheme, and it's not just in this law. I mean, prior convictions are used in felony DWI and grand juries and things, and I can understand why your client would feel that, there's some prejudice there, but where in the law is that prohibited, that would, they would think they're being handcuffed by this, and isn't this almost a first impression you're asking us to rule?
To the extent, yes, there's no case directly on point that I'm aware of. There's not. But what I would say is 265.033, I'm not saying they shouldn't use that subsection at all. But here, where the proof that it did not take place in a home or place of business was already elicited before the grand jury, based upon the testimony of the witness, the only eyewitness to the situation that happened. They established that it wasn't a home or place of business by saying they were just driving around, things of that nature. So to then say, well, we need to put the prior convictions in, it seems to me that there's a motivation to it. And then that conviction happens to be criminal possession of a weapon second. They elicit, not only do they put the certificate in, they elicit that it's a conviction for criminal possession of a weapon second through testimony, drawing attention to it.
Is it, but though, is it the prerogative of the district attorney's office to present that evidence in that fashion, the way they so choose? As long as it doesn't impair the grand jury?
Yes, but only if it's necessary. There was no necessity for proof of a prior conviction here under 265.033. Because
is it the fact that it's necessary, or the fact that they could have chosen a different alternative?
If it were a different subsection, Your Honor, I think maybe expecting them to choose a different alternative would be a bridge too far. This is under the subsection. They had all the proof they needed. The proof of the prior conviction was gratuitous. And we're under the same subsection that we're speaking of. So there are always multiple ways to establish something or do something.
Counselor,
Yes.
Justice Noack has a question.
I'm sorry.
I'm sorry. Sorry.
That's all right.
I didn't hear you.
You looked down for a second, so you didn't see me.
You're on a roll.
That's the problem. Well, though, I'm certainly glad you're appearing by video. The question I have is with respect to the order of the witnesses. It was my recollection that the certificate of conviction was introduced before the eyewitness testified. The father had testified, and so they brought that in, and then the father had. Am I wrong on the order? Did the father testify first and establish that this was not the home or place of business of the defendant?
No, I think you're probably correct on the order, Your Honor.
Okay.
I guess what I'm saying is it's not like they walk in the grand jury not knowing what they're going to do. So at the beginning, you put exhibits in, you do whatever you need to do. And then but I do think you're correct about the order. I don't think it matters.
Okay.
Would be the answer. Now, on the issue of justification, what I do want to say is that's a factual determination. You do have and the court saw the video, a person who was in a very, very dangerous situation. She gets in the vehicle, somebody gets in the vehicle, she has to kick them out. And then there are people, in my view of the video, there are people from this group walking toward her vehicle as those shots are fired. I think it was a determination that should have been for the grand jury to decide. And I think the court was correct in dismissing the indictment. Now, the other errors.
So is it your contention then that it should have been a question maybe for the jury to determine whether or not she had the ability or the option to retreat?
Yes, and whether the danger continued to be imminent, I guess would be the issue, and that's really what the prosecution's saying.
Well, was there any deadly force used by the son in this instance? He was sort of walking towards her vehicle, and she then, when she had the opportunity, as she was traveling away,
I mean, there was
That's
deadly
when she
force.
turned and fired. That's when she turned and fired though, but she was already out of harm's way.
Out of harm's way is a characterization. I don't necessarily agree with that. I think people are walking toward her vehicle and they just did use her. It's all part of really one incident. They don't take a break in between. So I believe deadly force was being used on her by them continuing to come towards her. Yes. Uh, because deadly force is anything capable of causing serious physical injury, and the slam on the car and onto the ground could have both. And I'll just leave it at that.
Okay. Very good. Thank you very much for your presentation today. Have a good day.
Thank you, Your Honors.
255, People versus Michael Viola. Ms. Schwartz, good morning. Can you hear us?
I can. Good morning.
Whenever you're ready to go.
Good morning. May it please the court, Melissa Swartz on behalf of the appellant Michael Viola. In my defense, I'm 8 months pregnant, so that's why I'm not there in person. I didn't.
That's
You never
quite all
know.
right.
You never know.
There's no requirement that, you fill out a medical form before you appear.
That's right. I just want to quickly touch on a point in point two. I recognize the cases cited by the people regarding point one, but I do want to make argument concerning whether or not Mr. Viola possessed the intent to menace the police officers. I'm obviously aware of the video. I'm sure the court has watched the video in this case. However, just to refresh the facts, which I think are acutely important in Mr. Viola's case, is he was attacked before the police arrived. That came from several witnesses in their testimony that he was attacked. He was suffering from whether it be a mental health issue or some sort of intoxication or a combination of both, resulting in him being attacked by several people. This put him into a defensive position where he then had an item in his hand, which I believe was a hatchet. I've looked at the hatchet. There's photos of it. And the police walk in on him in that defensive position. So this is not a case where the police come into a home or come to an area and someone affirmatively begins to menace them, right? Because they're trying to effectuate an arrest. He was already in that defensive position. He clearly was not in the right state of mind. And the entirety of the video, my view of it is that he remains in a defensive position instead of intentionally and assertively trying to menace the police.
Was he defensive? Was he defensive when? I believe my recollection of the record is that he encouraged maybe the police officers to shoot him.
I don't think that is an affirmative attack on them.
Is that defensive though, on his part?
I think it is a statement that certainly shows he was in a deep state of, again, either a mental health crisis or an intoxication, but he didn't say, shoot me before I blank do something to you, right? He was just saying, shoot me, you can tase me. He was defending himself from the beginning of it before the police arrive until the end. And I guess the one piece of the video that is in dispute for my argument would be whether or not, he cocks back, as the people describe it, the hatchet at any time. And I don't believe that that is accurate, that he, is doing anything affirmative. I think he's in a defensive position because of the state that he was in, and thus the proof was against the weight of the evidence concerning his intent to menace, because it has to be intentional. Unless the court has any.
Well, we have the video, we can see, the videos are long, there's a lot going on there. It's a small space, a lot of officers, and they had then the one individual that was there, I guess non-party, was there before they got him sort of free at one point when the defendant had fallen down, I think after the first taser shot. But in any event, tell me a little bit about the toxicology report or reports and the disclosure of them, and why that is something that you've raised in terms of the 30/30.
So in this case, as you can see, it's an extremely disjointed record. It's very unclear to me, from my review, what actually was turned over and when it was turned over, because there's not, great documentation presented to the court, and the court never really makes any sort of finding regarding Mr. Viola's repeat claims that he was suffering from a discovery violation. In terms of, I think the people and I have two disjointed readings of the toxicology report. Mine is that at some point a toxicology report, which obviously would be used in Mr. Viola's case to potentially defend himself with an intoxication defense, was performed at the request of the court. And that my reading is that the prosecutor did in fact possess that report. However, he did not turn it over because he said that Mr. Viola had equal access. That is not my reading of the discovery statute or the case law. My reading is that if he possesses it, he must turn it over. So I don't believe that he actually complied with his discovery requirements for the toxicology report. I understand the limitations regarding the disciplinary records. I think this is a unique case because it's not, an officer coming in and collecting a shell casing and then testifying about the collection of the shell casing. The 3 officers were victims of the crime. So there was something that the prosecutor could have done for due diligence. He could have sought court review of the records instead of intentionally withholding them because he did not believe they were relevant until a year and a half after. But regarding the toxicology report, I do think it needed to be turned over. It wasn't turned over. Unfortunately, I do concede that my limitation here is the lack of a record that's made by county court regarding those issues.
Ms. Schwartz, in reference to that, your argument here, I don't believe that the court below ever made a decision on your 3030 motion. Is that an accurate reading?
Correct. I don't believe the court actually made a decision on the discovery violations because at one juncture he says, well, I've denied them. And then you fast forward to the April court appearance and he said, yeah, we'll decide those on a different date. So I actually don't think he decides them at all.
Anything else?
Nothing else unless the court has any questions for me. Thank you.
I don't believe so, and congratulations again.
Thank you so much, Judge.
Good morning, Your Honor. Brad Oldler for the people. I'll go in reverse order since we were just talking about discovery. The tox report is somewhat interesting because, as the court noted, it was ordered by the court. I suppose in most circumstances, that's the sort of thing that prosecution might seek out themselves for use or to dispel a potential defense, whatever the case may be. But where essentially the evidence is created at the behest of the court, I'm not sure that it's necessarily the people's obligation then to acquire and turn over the item. But even if that is the case, the people did, I think the record does reflect that the people turned it over to the second attorney that was assigned to the defendant. And then when there were repeated claims, I guess, by the third counsel that hadn't yet been turned over, it had been at that point in time. I think there were also some delays between the successive counsels in turning the file over to their successors. But I think ultimately the tox report was turned over, and I don't think there's a viable 245 claim, or certainly not a.
Would it originally been in possession of the court then? The court ordered it,
That would be my position, yes. And if the court has, it's obviously.
It's your position. What happened though? Do we know?
Since it was ordered by the court, I think that has to ultimately be the analysis.
The court would have distributed to the parties.
Right.
We don't know.
If the record's not clear on that, I would say.
So it's your argument that on February 4th, you didn't have possession of the toxicology.
Right. And if it's created I think it is fair to say if something is created at the behest of the court, the result, I don't see it. It doesn't make sense to me to impute then the result of that order being put into the possession of the people, and now there's an added burden on the people as far as Article two
I mean, it depends
45.
what the order said. If the order said the people are to get this,
I suppose that could be
we
true.
don't know any of this.
If that were the case, I'd say that's a violation of an order that's,
Right.
it's a violation of a court order, not necessarily 245 per se.
But did the people have?
Well, so yes, I mean, it's,
Or
it's the report or the,
the report, yes.
yes, it's something we obviously did, yes.
No, even before the court ordered.
Oh, I'm
it,
sorry.
Didn't have the report.
No, it appears not. I,
Okay.
again, if I were the trial prosecutor, I suppose it's something I would have wanted, but
Okay.
it does not appear to be the case. in this
Do we have
instance.
in the record details as to, I mean, in terms of, it's not so much the report, it's what was drawn. I mean, he's taken to the hospital. He'd been shot 9 times. By the time, they get him, so you assume that the toxicology report is on his blood as opposed to urine or some other.
Correct,
substance.
correct.
The blood would have been drawn or taken from the hospital, I assume, or from the scene. I mean, do we know what's being tested, first of all?
As I stand here, I don't know for sure. I would very much assume it is blood because, I mean, you can see on the body cam, he's wheeled into the trauma center essentially. So
And
you would take blood there.
You would agree after watching some of the body cam videos that what's in his system at the time this is happening might be relevant.
I mean, I think I would want to know, yes. So it certainly is an item that would, I think, normally fall under the regular process of Article 245. I think this is a little unusual because the record doesn't suggest that it was something that the people had and thus fell within 245-20 right from the start. It would be a different scenario if it was. And I think, and then that sort of dovetails into the rest of the people's argument here, which is that, and this also applies for the disciplinary records, at the point in time when the COC was filed, which I believe was February 5th of 2020, there was no suggestion that we had a 245-50, i.e. a due diligence potential 3030 implicating flaw at that point in time. Certainly once 50A was repealed and the disciplinary records became fair game, and then later on we have the tox report being ordered and produced. Those, I would grant the court that those things have to be turned over, but any sort of delay or problem with the actual provision of those to the defense by the prosecution just becomes a 245-80 argument.
But what about the court not ruling on the 3030 motion?
If there are, I suppose, I would have to take the stance that if there's fleeting mentions by the court of I've denied those or something to that effect, I think that's the decision of the court.
Because your opponent was referring to pre-trials, I believe, that on discovery issues.
Mhm.
But I'm talking about, wasn't there a 3030 motion? Were there separate motions, right?
Yes, there was a 3030 motion made,
Right.
I think, by the third attorney sort of later in the proceedings. My reading of the record would be that those have been denied sufficient for this court to review whether there's any sort of error in terms of the case proceeding. If the record is devoid of a clear indication that those were decided, I suppose that is something then that would have to be sent back to be decided by the trial court.
Or perhaps the last 2 of the 3.
Or correct, yes. But I don't know, I wouldn't normally make this suggestion, but I think the record here is certainly sufficient for this court to decide the issue, because I don't think there's no sort of unanswered question or amplification of the record that would need to take place by remitting it just for that determination.
Seems like there's only a challenge to the 2420, the initial COC, right?
Right, that would appear to be the case, and I think as far as a 3030 sanction related to that, I don't think there's any grounds for that. I can speak to the weight of the evidence if the court would like. I think the intent aspect is clearly inferable from the video. I would certainly agree. It certainly seemed like there was either a mental health or maybe both mental health and potential intoxication issue. But that being said, just because one of those or both of those exist in combination doesn't negate the intent. And I think the video kind of speaks volumes on that. If there's anything else, I'm happy to answer other questions.
None. Thank you.
Thank you.
Case number 259, the matter of Beth Lockhart versus Melissa Monica. Both appearing virtually. Good morning. Can everyone hear me?
Good morning. Yes, thank you, Your Honors.
Mr. Pillich, is that right? Can't hear you. Can't hear you. No, I don't think he's muted. Counselor, I can't hear you.
Your Honors.
Yes.
Mr. Pellich appears to not have joined with audio. We can address this with him if you would like to move on to another case.
All right. We're going to come back this after Mr. Pelch. After you address the audio. All right. Now you're muted. Can you hear us now?
I can hear you. Can you hear me? I'm so
Okay.
sorry.
All right. You've corrected it. All right. Welcome back.
My apologies. To be
No
honest,
problem.
I broke my primary computer yesterday, and I'm using a borrowed computer right now, so I'm not fully set up. That's another issue for another day.
We can hear you and see you. That's good. All right.
Okay.
Go ahead.
Thank you. Thomas Pelch for Melissa Monica. Good morning, Your Honors. May it please the court. This case presents an interesting yet narrow legal issue, and that's whether or not an AFC has a statutory authority to initiate a family offense proceeding against a non-parent to a family court proceeding.
Does the child have a right to bring this proceeding?
I don't think so, based on the Family Court Act or the case law. There is some language in one of the cited cases that we'll get to where the court said that the AFC could have acted on behalf of the children, but I believe that's only in relation to a proceeding that had already been initiated, not to initiate a proceeding itself.
Well, wouldn't 822A, the Family Court Act, give the child the authority to bring the action against the grandmother as they're members of the same family or household?
I'm not sure on that, Your Honor. I would have to take a look at the language there and get back to you. But I apologize. I don't have the answer to that.
No, that's quite all right. No problem. Go ahead.
Okay. It's our position that Section 812 of the Family Court Act, which details who can initiate a family court proceeding and to whom it can be initiated against, doesn't include an AFC as an authorized petitioner of the court. The case law on this under both Pamela N. and Berg, which are the discussed cases in the briefs, I would argue that they actually support our position because in both of those cases, the original action was initiated by the parent who was involved in the in a family offense or a custody proceeding. And here, there was an ongoing custody proceeding, but there had yet to be a family offense proceeding that was initiated.
I think in Pamela N., the court did say that the children could have originated the petition against the father themselves.
They did, citing Berg, but in Berg that wasn't what had happened. So it's a little bit confusing as to where the court came to that language. And then also in Pamela N, the same thing. So I would just ask this court or the Court of Appeals whether or not that would include initiating a proceeding as opposed to participating in a proceeding, which is what had occurred in both Pamela and Berg.
Okay.
Counselor, what about the hearing officer's recommendation? How do you think that plays in with subdivision D?
I think that in this case, there's no argument that Miss Monica was difficult and perhaps even her behavior, was well past the bounds of acceptability. However, we would submit that still doesn't grant the court jurisdiction where it otherwise did not possess it. So regardless of, the acts of Miss Monica and the recommendations, we would submit that the court did not have that authority. There were other mechanisms to deal with Miss Monica, but the AFC acting independently on behalf of the court and initiating a family offense proceeding was not one of the available remedies.
Counselor, was the petitioner child the named petitioner or was the AFC the named petitioner?
I believe
Did the
that it
petition
was
say the child's name?
I believe
and-
so, yes.
Okay.
Yes. So I think at the end of the day, that's the question for this court to answer. And if there are no other questions, I'd be happy to rest on the very voluminous briefs that we've both submitted.
Very good. And we'll look at that, your argument very closely.
Thank you.
Soccer. Good morning.
Good morning, Your Honors. First and foremost, I am here as this child's attorney. And to be very clear, my position is that we wouldn't be here but for the family court clerk changing the caption of this petition. At my initial filing of this petition as the attorney for the child, I filed this petition JD as a minor versus Melissa Monica. The family court clerk sua sponte required that the caption be changed to petition of either Beth A. Lockhart or Lockhart Law Office, I don't remember which, on behalf of JD, a minor, versus Melissa Monica. But for that occurring, we wouldn't even be having this discussion with this court right now. I would further point out to the court that pursuant to Family Court Act 822, there's 4 categories of persons that have standing to bring a family offense petition under Article 8. The first category is the person that's subjected to the alleged offense. JD was the subject that was it was the person being subjected to the offenses being committed by Miss Monica in this proceeding. And to be clear, I also believe that under Family Court Act 822, my position as an attorney for the child under the 4th Department falls under an additional category of the 4 categories designated in 822, specifically that a peace officer, or I'm sorry, not a peace officer, a duly authorized agency, association, society, or institution may commence a proceeding. To be clear, pursuant to 22 NYCRR 1032.1, the 4th Department Attorneys for the Child program falls squarely in the definition of a duly authorized agency, association, society, or institution, providing explicit standing for an attorney for the child to file a petition on behalf of a child. I think what the appellant is doing here is asking you to engage in a very slippery slope, and here's why. Essentially, the appellant's arguing to you that as this child's attorney, I didn't have standing to file a petition on behalf of the child. Now, let's look at that at the broader standpoint. Let's look at it from all petitioners, not just a child. They're asking you to say that an attorney would never have standing to file their client's petition for a family offense in any family offense proceeding ever. That would mean whether it's an adult, whether it's a child. That's what the appellant is asking you to rule here. And that would effectively deny victims of domestic violence who are protected under Article 8 any effective assistance of counsel, and it would deny their 6th Amendment right to counsel. And that's a slippery slope that I don't think that this appellate division would like to go down, because we've expanded, our governor has expanded Article 8 with Melanie's Law. In November 25th of 2024, our governor signed into law and made effective expansive provisions under Article 8 to enhance who could be a respondent in an Article 8 proceeding. And the sole aim and goal, according to the legislative history, was to ensure the protection of children. I would also like to point out to this court that had either parent, biological parent of this child, filed the petition in Onondaga County on behalf of this child, because neither parent was the victim of the alleged family offenses, I would have been forced by the sitting judge to step into the shoes of the parent who filed the petition and prosecute the Article 8 petition, because that's how they're handled in trial court, is if the child is the sole victim, the attorney for the child has to prosecute the petition. So it's of no consequence that I filed the petition because we would have been in the same boat regardless. I would further point out to the court, as outlined in the record before the court here, that we had already exhausted all of the avenues to prevent the appellant's conduct in the custody proceedings involving both of the biological parents. By the time the family offense petition was filed against the appellant, we already had an order that had been stipulated to by both biological parents that neither the biological parents nor their extended family members would engage in contacting law enforcement or child protective services simply to engage in status checks of this child. Then, when that didn't stop it, the parents both stipulated that the appellant here could have absolutely no contact with the subject child. And the court entered an order under the custody proceeding pursuant to Family Court Act 656, effectively ordering, on stipulation of both parents, that neither parent would permit JD to have contact with the appellant. However,
The appellant here was not a party to that agreement, not that.
correct, correct. And so what?
So is that why then you had to bring a petition for family offense petition?
That is absolutely correct, because the problem that we found is that even with the order of protection in place under Family Court Act 656, it was unenforceable as to the appellant. And unless we could demonstrate under 656 that one of the biological parents was encouraging her, meaning the appellant, to engage in this behavior, there was zero enforceability. And meanwhile, my client has authorized me to say 3 words to this court. These are the 3 words that prompted the filing of the family offense petition for the petitioner JD. Make it stop.
Counselor, what's your position on the matter of Abduch, ABDOCH, where the children in custody rights do not have a full party status?
So that is distinguishable here because this case is not a custody proceeding. And I would point out to this court that the appellant is not a parent to this child. The appellant also has no established rights under Domestic Relations Law 72 as to this child. She has never made application for DRL 72 custody rights. She doesn't have standing for it. There's no extraordinary circumstances. There's never been a finding of extraordinary circumstances. And she had no rights to visitation with this child. And both parents, prior to the filing of this family offense petition, had expressly stipulated in the custody proceedings that she was to stay away from this child.
Okay. I think we understand that.
I just have one question. Did you ever ask the court to issue the order of protection pursuant to Family Court Act Section 822 subsection 4, which is the court's inherent?
I expressly asked the court when the custody matters were pending in front of court attorney referee Rosario. I expressly made application under Article 8 and 656 that an order be entered explicitly prohibiting contact between appellant. That application was denied by the court, and I was directed by the court as the child's counsel to file a petition on behalf of the subject child as the petitioner and proceed with the litigation.
Very good. Thank you very much, Ms. Lockhart.
Thank you, judges.
All right, have a good day.
You too.
Next matter is 260, James Harris versus Brian Root.
Good morning, Your Honors. Please excuse my voice. I'm a little under the weather, so if you can't hear me, please ask me to speak up and I'll be happy to do so. Jessica Tarek on behalf of the defendants appellants. Our position, Your Honors, is that this motor vehicle accident, based on the record evidence, is the results of the sole negligent actions of plaintiff in executing an improper left turn without signaling from the wrong lane, without looking for oncoming traffic, without slowing or stopping his vehicle, and directly in front of my client, Mr. Root, who had the right of way at the time of the accident. I think
Because you're claiming still that he had the yellow light.
based on 3 accounts, the deposition testimony of Mr. Root and the 2 eyewitnesses who provided sworn statements, the record shows that, those witness accounts of people on scene is that he did enter the intersection at a yellow light. There's nothing that prohibits him from doing that.
Sure, but the video.
The video is certainly something I'd like to address. Certainly we can see the cross traffic light and the fact the light goes from red to green in the video. I don't think that, there's anything definitive in the video indicating that Mr. Root entered the intersection on a red light. I think any sort of
So you're suggesting that his light was yellow while the oncoming traffic light was green. So a defect in the light. So both parties thought they could go.
Well, I believe the light for the cross traffic that you can see in the video is initially red. And there is, I believe it's Mr. Boardway, the witness who provided a sworn statement who stopped at that red light. As you can see Mr. Root traveling through the intersection. And I believe
We're going to go with a witness's recollection as opposed to a video that shows exactly what happened at the time of the accident.
Well, I guess our position, Your Honor, is that the video does not definitively show for County Route, or excuse me, for State Route 3, that the light was in fact red at the time that Mr. Root entered the intersection. That comes from plaintiff's expert.
You don't think the video even creates an issue of fact?
We don't believe so, Your Honor. We believe, based on the witness statements of 3 individuals who are providing an undisputed version of events as to what happened that day, that the testimony and the sworn statements are that Mr. Root entered the intersection on a yellow light. And I do want to address, if I can, that expert affirmation. I think, the expert affirmation of plaintiff does try to use the video to conjecture or speculate that the light for Mr. Root was red at the time that he entered the intersection, as a way to kind of impute some sort of negligence.
Saying before, entered the intersection was red. The expert was saying.
Right. That's one of the expert's ultimate opinions. But I do think there are issues with the foundation for those opinions.
Well, he also, part of his opinion also is that even the defendant's own testimony, it takes a certain amount of distance to stop this dump truck. And based upon that, with the timing of I think it was 1.9 seconds between the different, when the light turns red and then the other one's going to turn green. So there was some time there, so based upon all that, he's configured all that into his opinion.
Yes. And I do want to address the 1.9 seconds, the 3.9 seconds. I think there are some issues there because plaintiff's expert surveyed the timing and the sequencing of these traffic lights some 2 years after the accident. There's not even an attempt in the expert's affirmation to lay any sort of foundation for the fact that timing and sequencing was the same at on the date of this accident or at the time of this accident. I think the ultimate opinions of the expert do come down to, the video and the timing and the sequencing. But I think there are some real issues with.
Sometimes municipalities or transportation departments keep track of the records of the lights, the sequencing of the lights. I assume that was researched and analyzed.
Well, I would think if there was a stronger basis for that opinion, that plaintiff's expert would have included that in his affirmation to provide, a real basis for his ultimate opinion that, for instance, the yellow light was yellow for 3.9 seconds, the red light was red for 1.9 seconds. I think, as you can see from the videos of, plaintiff's experts on-site inspection, there are some, issues in terms of counting for the yellow light. There's not really much of a basis for, him using a stopwatch versus counting out loud. I think there are certainly some issues there that indicate that the counting was not consistent. And the method for collecting that information cannot serve for the ultimate opinion that he provides.
Anything else?
There's nothing else from the panel. I'll rest on my papers.
Very good. Thank you so much.
Thank you, Your Honor.
Good morning, Your Honors. Matt Kaiser for the respondent, James Harris. And just at the outset, I want to note that an argument was raised for the first time on appeal here as far as the timing of the signal and the calibration. That's not an argument that's raised in the appellant's brief. It was an argument that was raised by them below. But the only argument raised in the appellant's brief as far as the methodology behind expert McMahon's opinion goes to causation, as far as whether there was a basis for him to conclude that there was causation insofar as the plaintiff would have relied on the traffic control signal on State Route 3 being red as a marker that it was safe to turn. So I would ask the court to not probe into that argument as to the timing and the signal calibration.
What in your mind creates an issue of fact?
Well, in this case, we have extremely close in terms of what, Your Honor, the red light or?
No, your
Okay.
argument, it's
Okay.
your time to try and convince us.
Right, and so as Judge Nowak noted, we have here a sort of reverse extrapolation from the video by our expert as to what the color of the light was on State Route 3 when Route entered it.
You have those two witnesses that say it was yellow.
Well, those two witnesses, as Judge Nowak noted, right on the face of the video, it's contradicted. And also we have an expert opinion here that's, I think it's a very impressive expert opinion that goes through a very thorough methodology explaining what the timing was. And again, if defense counsel is now claiming for the first time on appeal that there is no basis for the signal calibration based on expert McMahon's firsthand recollection, albeit years later, well, that's a credibility issue. That's a credibility issue. And if they had come forward with maybe something from DOT saying, no, the signal changes based on the time of day, signal changes based on the time of year, then you've got an argument that it's speculative. But the only thing speculative.
To be fair, I mean, there wasn't a cross motion filed. They did have a reply, though. They did have a reply affidavit. I mean, I don't know if there's time to get the records that I referred to. But what you're saying is in the reply affidavit, there was no argument made that the analysis was remote in time from the date of the accident.
I will concede, Your Honor, that was in the reply affirmation below. But it wasn't in their appellant's brief before this court. So I would say that argument's abandoned because they only focused on causation in relation to McMahon and so I just wanted to note there's an argument, it's not discussed today, as to the sufficiency of the pleading and as far as whether the color of the light was an issue that was before the defendants and whether they were on notice that this was a component of our claim of negligence. And really, if you look at the moving papers, it's very clear and it's very cognizant to the defendants that Ruth's negligence is a function, at least in part, of whether the light was green or red when he entered the intersection. And so I'm available to discuss that this morning. It's in our brief. The moving papers are littered with references to yellow light, yellow light, yellow light. And that's why they have the affirmations of those non-parties. They knew this was front and center. They knew that the color of light was important. We don't have VTL 1111 in the BOP. Maybe we should have. We do have 1212. Reckless driving, and there's a recent Second Department case that came down a month before we put in our opposition papers saying that when you go through a red light, that can support a claim of reckless driving. So
the police report says that the defendant went through red light, correct?
Exactly, and they're well aware that that's a major component of Ruth's negligence.
So it's your argument, the police report, the video, the expert's opinion, they all create an issue of fact.
Yes, Your Honor, that's our position this morning. Thank you.
Number 262, on the matter of Caroline Dietrichs Wheeler against Christopher McAvoy. Both counsels are appearing by video. Ms. Conley and Ms. Gray, good morning. Can you hear us?
Yes, Your Honor.
Yes, I can hear you.
Ms. Conley, whenever you're ready to go.
Thank you. Your Honors, may it please the court. It is our position that the mother's petition properly alleged a change in circumstances. That is, the professional charged with supervising the mother's visitation had concluded that the child was safe with her mother, that the mother acted appropriately during visitation, and that supervised visitation may not be warranted. The case law confirms that supervision can interfere with the parent-child relationship and that it should only be imposed where unsupervised visitation would be detrimental to the child. So, Your Honors, we have a legal standard here, detrimental to the child, and facts suggesting that this legal standard is no longer met in the instant case. So it's our position that the petition adequately alleged a change in circumstances and should not have been dismissed. It should be noted, Your Honors, that the prior order was entered on consent and therefore is entitled to less weight than a disposition after a hearing. We don't have a judicial finding, Your Honors, after a hearing that unsupervised visitation would be detrimental to the child. Also relevant, Your Honors, is that the prior order was almost 4 years old at the time that family court dismissed the mother's petition. Concerningly, Your Honors, the family court seemed to focus on the fact that the mother had filed prior petitions, but just because the mother had filed prior petitions didn't mean that this one lacked merit. So unless the court has any questions, I'll rely on the brief.
Very good. Thank you, Ms. Conley.
Thank you.
Ms. Gray, good morning.
Thank you, Your Honors. Good morning. Ms. Conley neglects to tell the court that in the 3 years following the initial order, the mother did not exercise any visitations whatsoever.
Well,
And
did the mother continue some phone calls though with the child?
she has continued the phone calls on a regular basis.
Even during that 3-year absence period you're
Yes.
talking about? So there were phone calls? There wasn't just a total abandonment of the situation?
Correct.
Okay.
Correct. In the last 14 months, she's exercised 8 visits. More importantly, my client does not want the situation to change. She's 9 years old. She's thriving in her placement with her father. She's doing very well in school. She's in extracurricular activities such as dance and orchestra. And it is her position upon which I advocate that the initial order continue and that the petition that her mother filed be dismissed.
Anything else?
No, Your Honors.
All right, very good. Thank you so much.
Thank
Good day.
you.
Case number 264 is Nuco Capital Group LLC versus SPE Trading Inc. Both attorneys are appearing again by video. Counselors, can you hear us?
I hear you.
All right, very good. Ms. Luftig?
Good morning, and may it please the court. I'm Allison Luftig on behalf of the appellant. This appeal arises from the granting of summary judgment in favor of the respondent, Nuco. And in the appellant's view, this order should be reversed for several reasons. First, the respondent failed to establish a prima facie case for entitlement to summary judgment under the burden set forth by CPLR 3212.
Counsel, with respect to their burden, it seems that on a breach of contract case like this, they need to demonstrate that they performed. And I saw in the affidavit that they said that they funded it in the amount, in the purchase amount, which my reading of the contract is $700,000 less applicable fees, which looked to me to be about $35,000. An origination fee and an underwriting fee, I think. So then it said, see Exhibit C as to the basis of the funding. So I went to Exhibit C and it's a bank statement, and I thought it would show a deposit of $664,000, something like that. It shows $283,000.
Right, that's a
What
problem.
does that mean?
We don't know, and it's not our evidence. So that is actually a part of our argument that their exhibits are not self-explanatory and sufficient enough to satisfy the evidentiary requirements for summary judgment. That was part of our issue as well.
Right, but you don't have an affidavit from your clients that say, well, we never got the full amount. We only got a third. of what was coming to us on the front end. So they haven't performed. I don't see that argument either, but are you saying you don't have to make that argument?
I'm saying since the burden didn't shift, since they didn't meet their threshold burden, as I was getting into, that we didn't have to submit such factual evidence in opposition. There are even some cases focusing on this threshold burden that focus on the fact that summary judgment must be denied if the burden is not met, even in complete absence of any opposition, let alone an affidavit.
Well,
So-
doesn't the record show that you paid the plaintiff, your client $533,000? That's right. That's in the record, right?
I believe that is what their payment transaction history portrays, but that's another in our view, a non-self-explanatory document. So I can't say much more without it being hearsay, since I'm not the one making the payment.
If what they said was true, that there were these withdrawals from a bank account and then it stopped at a certain point, there's a bank statement that exists that would be generated by the bank that would reflect that, but that's not what they attached, right?
Right. And that is another issue I was going to bring up, that there has been a trend of case law that does require accompanying bank statements that are separately authenticated, and that proof is absent here.
Well, if they put in proof that they paid you $533,000 and you don't dispute it, you don't think you have to dispute it? That's what you're telling us?
I'm saying since we believe their threshold burden was not met, we don't have to dispute it at this time.
But you don't even say that. I'm sorry, but you don't even say you don't, like, you're not making Justice Nowak's proposition that, there has to be a bank statement or anything of this. That's not in your papers, is it?
I believe it was in the evidentiary section. I believe it was either in the appellate brief, the reply, or both, and definitely in the papers below.
Below, you only submitted a memorandum of law, isn't that correct?
Yes.
There was no affidavit of an individual, of a person with knowledge, correct?
That's correct. And it's for the same reason I'm giving here about them not meeting their original burden. So.
Anything else?
Yes.
Go ahead.
Let me just make sure. Okay. And additionally, their motion relies almost entirely on one employee's affidavit. And as we discussed, records that mostly appear to be generated internally without the bank documents to back it up, and perhaps an affidavit from somebody who would know what those meant and be able to explain it. So their submissions don't establish sufficiently the elements of a breach of contract as required for summary judgment. And next, I wanted to address their affidavit and business records a little more, just to explain why I'm saying they're deficient. I believe the respondent's affidavit by Nick Colasar in many areas fails to establish the requisite personal knowledge required for the grant of summary judgment. Instead, it contains assertions that the attached documents were prepared by individuals with firsthand knowledge of the recorded facts, but the affidavit never identifies who those individuals might be, if they work at respondent's entity, something else. We really have no explanation for that, or how respondent's affiant could possibly know that information. So I believe the requisite personal knowledge for summary judgment is not established, in that we would need it to be no question that this affiant is qualified to set forth the facts that he is setting forth, and that level of proof is absent here. So the lower court should not have accepted this affidavit as competent evidence, or the business records that it refers to. And I won't go too much into this because we talked about this with some of your questions, but I just wanted to reiterate that the payment history does not actually establish a breach of the specific provisions in this MCA. There has been a case law trending that holds that basic payment transactions like this cannot prove a breach of an MCA by either party. And like I mentioned before, this one just simply is not self-explanatory enough. So these deficiencies at the very least raise questions as to the foundation of the evidence and should have precluded summary judgment. And lastly, there are just still existing material facts that we brought up that are not sufficiently handled by the record. We brought up issues with the formation of the contract, the enforceability. We brought up several affirmative defenses, specifically including usury and unconscionability. So there are questions of fact as to whether this agreement really functioned as a loan and not a purchase of future receivables, and as to whether certain clauses give rise to unconscionability. And if there are no other questions from the panel, I will refer to my papers for the rest of this. Thank you.
Thank you very much, Loftig. Thank you. Mr. Neiman?
Good morning, Your Honors. May it please the court, my name is Jacob Neiman of Carter, Ledyard and Milburn on behalf of the plaintiff. Just to address the evidentiary issues first, since that seems to be the topic of the day. The trial court had discretion to accept the affidavit as pled. The courts always defer to trial court's evidentiary rulings. In this case, the affidavit of Mr. Colasar, who's identified himself as an employee of Nuco Capital, sets forth all the requisite elements of 4518, including the fact that he has personal knowledge of the makers of the document makers' practices and procedures, which distinguishes it from all the cases that required more detail.
Counsel, does page 66 of the record, Exhibit C, does that contradict the affidavit?
To address your question from before, no, it doesn't, for a few reasons. One, many of these transactions are refinancings or paying off of other existing debts of the company. And yeah, I've seen that before. Is that something that would have needed to be pled? Say that, well, you know, we really didn't fund 700 because they had another deal, and then they breached that deal, and so now we made another deal for 700, but since they owed us 400 on deal number one, we only funded 283, which is what's the amount in Exhibit C. If that was the case, does that need to be pled in support of the motion for summary judgment? Does that need to be alleged? Because it would otherwise, it would seem that Mr. Colasar's affidavit might be a little misleading or incomplete. I don't believe it was intended to be misleading. I don't believe it needs to be pled because there's no dispute here that the amount was funded. That the purchase price was paid. If there was, there would have had to be an affidavit in opposition saying, well, there's a discrepancy here, and there isn't. And frankly, there's pleading that they've complied with their funding obligations. There's no dispute that they complied with their funding obligations. In fact, the merchant paid $533,000 over the course of time as weekly remittances. So if this wasn't funded, that would have come up. But merchant failed to submit any affidavit in opposition. They've raised no dispute. And frankly, the standard on summary judgment is that a court shouldn't blindside parties with issues that weren't even raised.
Right. No, I appreciate that. But you also have a burden on summary judgment. With respect to this idea that, again, this is now the second deal, that there was a first deal and that we now worked in with more money in the second deal. There is an argument that's being made that 7% of their accounts receivable, that was a good faith estimate. The good faith estimate is something that would need to be established, right? Because otherwise, if you didn't have a good faith estimate of the revenue, then it's really not a revenue purchase agreement. if there's a prior deal that was then renegotiated, wouldn't the good faith estimate of the revenue be important on the prior deal if it's inconsistent? With this, that means that your client knew that that wasn't really a good faith estimate.
Your Honor, you're making arguments that weren't made by the other side, and frankly, I don't know if they're reflected in the record. What we have here is a stipulation by the defendants that that is a good faith amount. That's on the first or second page where they expressly say this is a good faith estimate. And in every contract case that I'm aware of, a party's signed agreement without any evidence to the contrary is prima facie evidence that that's true. Now, if they wanted to raise the fact that that the funding wasn't the true amount, and I've read Your Honor's concurrence in the bridge funding case, if they wanted to raise that issue, they should have submitted an affidavit. There's frankly nothing here. There's no record here to indicate that anything here is untrue. That was
there's nothing in the record to indicate they were coerced or anything into this agreement. Nothing that they were not
absolutely
a sophisticated party entering into a complex commercial transaction.
They can afford $35,000 remittances per week. They are very sophisticated. This is a LLC. This is a sophisticated commercial setting. There's no indication otherwise. There's no indication that anyone was duped. I'll point out
did this come to us from the commercial part too? You know, was this a commercial part case in Supreme Court?
I'm not sure. I frankly don't know. But I can tell you the amount would have warranted a commercial case, the amount of controversy. I can also tell you that this agreement is identical to the agreement that this court found is a true purchase of receivables in the Sampson MCA case. It's identical to the agreement in Apollo funding from the Second Department of last year. This is a agreement that's been tried and proven to be a purchase of receivables, and there's no evidence to the contrary. There's no evidence submitted because there's no affidavit submitted that they sought a reconciliation. There's no evidence that the amounts don't reflect the true amount of their receivables. Everything here is a clean merchant cash advance collections case. And frankly, if they wanted to challenge that, they had every opportunity to say we need discovery through an affidavit in accordance with 3212D. They had every opportunity to challenge, in opposition to the motion for summary judgment. If Colasar did not have personal knowledge, why didn't they submit a 3212D affidavit saying we need discovery about information that's in the exclusive possession of the plaintiff? They didn't. This is a case where the motion judge acted in his discretion and accepted the affidavit as sufficient. Now, there's other judges that may have found otherwise in their own cases, and I think there's one or two judges in Kings County and Brooklyn that have said that, but that's not
okay, Mr. Neiman. We don't have to get into that. Well, just let's do what we have here. You know, we're not bringing other cases we don't need to look at right now. Anything else, Mr. Neiman?
With that, I'll rest on the papers.
Very good, counselors. Thank you very much for your appearance today.
Thank you.
Last case, Lewis Shattuck versus Dryden Mutual Insurance Company.
May it please the court, Mark Whitford for the defendant Dryden Mutual Insurance Company. In this case, the trial court properly vacated the underlying judgment and ordered a new damages inquest. However, we submit that the trial court did not go far enough and should have dismissed the complaint based on the insured's failure to forward all the underlying suit papers to Dryden. Or at a minimum, the court should have vacated the underlying judgment and allowed the insured to litigate the case on the merits. On the first issue, the trial court should have dismissed the complaint because there's no dispute that the insured failed to forward all suit papers to Dryden. The insured knew about the default motion that was filed, and in fact, he worked with the plaintiff's attorney to allow a default judgment to be entered against him. Those facts are undisputed. The only issue that's in dispute between the parties on this issue is whether the insured had an ongoing obligation to forward the suit papers to Dryden after Dryden indicated it was not going to defend the insured. And on this issue, we cited a number of cases, including from this court, where courts have held that a simple denial of coverage, even with respect to the duty to defend, does not constitute a repudiation of the policy. And the key is whether or not there's a repudiation. And whether there's a repudiation turns on whether the insurer attempted to shape its conduct in accordance with the policy. That's the standard. And I point specifically to the Seward Park decision out of the First Department in 2007, which went through in detail the difference between a denial of coverage versus a repudiation of the contract. And then this court followed that decision in the Armstrong versus United Frontier case in 2020.
There's no dispute you denied coverage, right?
No dispute, Your Honor. We do not dispute that.
You denied to defend, you denied to indemnify.
We did, Your Honor. We do not deny that there was a denial, but the key is the Dryden did that after an investigation of the case, which included, among other things, hiring an investigator, taking a statement from the insured.
Well, didn't Dryden think that the injured individual was an employee?
That's exactly.
There was a thought. I mean, but they also in the pleadings indicated, well, it's either an employee or an independent contractor.
That's correct.
The court below may have indicated or looked at the independent contractor status. If that's the case, if there's an independent contractor status, is that automatically or should that trigger at least the duty to defend?
The answer is yes, it does. That was the mistake that was committed here. And we fully acknowledge that. But that is where there is a denial of the duty to defend after an investigation. But the key is the carrier looked at the facts, made a mistake. We acknowledge there was an allegation of an independent contractor.
So is that mistake a repudiation?
It does not, Your Honor. And that's per this court's decision in Armstrong. That's not a repudiation of the contract. And it is a fine distinction. And that's why the Seward Park decision makes it very clear. A lot of confusion on this because courts in the past had confused a denial of coverage versus a repudiation. But where you investigate the claim, and even if you get it wrong, we work with that assumption. But if you're intending to apply the terms of the contract and you get it wrong, that is not a repudiation. That's a breach of contract. That is, but it doesn't excuse the ongoing obligation to comply with the agreement. And here, that's what failed to occur. When Dryden denied coverage,
didn't I say denied coverage or denied to defend? Even then they tell an individual, hey, get your own attorney.
Well, they did, and the record is clear. Well, they did, but to be clear, they did that based upon their investigation.
Okay.
And including the statement from the plaintiff's attorney indicating that he was an employee, and they came to the conclusion that he was an employee and denied coverage. However, they said, please continue to keep us posted of any developments per the policy conditions.
But separate and apart from that, the material breach of the duty to defend, that can serve independently to extinguish the duty of the insured to provide documentation, can't it?
Well, that's where we disagree, Your Honor. That is where I think this court's decision in the Armstrong decision says otherwise. That again, and it's the term used by the court in Seward Park and this court in Armstrong, that a run-of-the-mill breach of contract does not constitute a repudiation of the policy. The case is dealing with repudiation. To highlight the differences, a repudiation is if you have a carrier who says, I'm going to rescind the policy based upon a material misrepresentation. I'm not going to even honor that contract because you had misrepresented something. We're not following that. Another case cited by the court indicated where the insurance company immediately disclaimed coverage without any investigation can constitute a repudiation. And acknowledgement by the carrier to say, I'm not even going to look to the contract to determine whether it's not about whether or not the carrier got it wrong. That is okay. That is a breach, and we acknowledge that. The remedy for that is to pay for defense costs. If the insured incurs defense costs and incurs those, they would be entitled to those for that breach. But what it does not do is it does not excuse the ongoing obligation to then forward the suit papers. And that is the obligation of the insured. That's what they breached, and that's why the suit should have been dismissed. But let me turn to my second point, because that's really what the court focused on. The court didn't agree with us on the first issue, and for all the reasons I submit that's wrong. But the second issue, Your Honor, is that ultimately, in the interest of justice, the trial court held that the inquest damages needed to be set aside. And why? Because there was a number of undisputed facts, including the insured answered this lawsuit 1 day after it was due. It was personally served. 21 days later, the insured filed an answer. That same day, the plaintiff filed a default motion. And then the court, instead of addressing the fact that the insured did answer the lawsuit and deciding whether to excuse the 1 day delay, the insured's personal counsel and the plaintiff sent a letter to the court clerk the very next day indicating, we've got a plan. We've decided we're not going to go back to the insurance company as they asked us to do if the workers' comp carrier didn't defend. Instead, we want to have a gotcha moment. We want to take the breach of the duty to defend, and we want to go right to an inquest, and we don't want to tell the carrier about it. And the court then entered a $2.8 million judgment against the insured. And they did all that because the insured agreed to it. And we've cited a number of cases where even in a direct action against the carrier, if the underlying judgment is fraught with fraud, collusion, misconduct of any kind, and in here that's what occurred. Well, there's an email between the parties to the court indicating, here's our plan. This is what we're doing. And I would add that that email was sent before there was an assignment and an agreement that the plaintiff would not execute against the insured. This was a plan that was in place. The assignment didn't take place until 2022. In 2021, the plaintiff and the insurance counsel were agreeing that they would go forward and allow a judgment to be entered against the insured. That if the trial court found that misconduct, what the trial court said was troublesome, if that was troublesome, the court should not have just simply vacated the inquest. It should have vacated the default itself. Because again, the insured answered the lawsuit 1 day after it was due, and the court completely disregarded that. And so, if in the interest of justice, if the court decides not to dismiss the complaint and find there's no coverage, at a minimum, we should go back to where this all should have been, which is to vacate the underlying default, allow the case to be decided on the merits, where Dryden is affording coverage to the insured. If the insured's personal counsel has legal fees that need to be reimbursed, we would address that. But that is in the interest of justice, that the court found that was the appropriate remedy. It should have been to vacate the underlying default itself. And unless there's any other questions, I'll rest on the papers.
Very good, thank you. Mr. Orndorff.
Thank you, Scott Orndorff, on behalf of the respondent. So I have a cross appeal here. It's our position that the court, having found that there was not a fraud upon the court in the underlying action, which there was not, should not have ordered a new inquest. The carrier is, if they choose wrongfully not to defend, they are stuck with the damages as well as the liability in the underlying action and cannot challenge it. This theory also was brought up for the first time in response to summary judgment. It's not pled in the answer and should be disregarded for that reason as well.
Mr. Whitford argues about Armstrong. What's your position on the Armstrong case?
In that case, I don't believe, Armstrong and that whole line of cases, in those cases, there's either no duty to defend at all, where it didn't involve the breach of the duty to defend, or there's a question whether there was a duty to defend or not. Thus, there's no summary judgment in favor of.
Was there a question here on whether or not there's a duty to defend? I mean,
no, here it's clear that there was a duty to defend and it was breached. In these other cases.
Why is it clear? I mean, there was a claim that he was an employee. They did an investigation. This individual was an employee, and workers' compensation should then have been the correct method of recovery or addressing the injuries.
No, the duty to defend is triggered by the four corners of the complaint. Because there's an allegation in the complaint in the underlying action.
Because there's that alternative. He was either an attorney, he was either an employee or an independent contractor. But those three additional words makes it a duty to defend.
That's correct.
Because there's a reasonable what's the terminology they use? It's a reasonable opportunity to or obligation to defend or indemnification, something along those lines.
Yeah, I think it's even more, it's a very broad, the duty to defend. If there's any allegation in the complaint that would trigger coverage, in this case, I think it was meritorious, but whether it was or not, the duty to defend is triggered.
But again, as Mr. Whitford has indicated that they continued the investigation and there was still a claim by Wazinski, well, maybe workman's compensation is is still looking at this. We haven't heard from them. You know,
Well,
Does it
what they should have
affect it?
done then is to defend under a reservation of rights.
so they never made a declaratory judgment either. They never brought something like that to determine whether or not there is this duty to defend or indemnify that would probably have covered them in that respect.
Well, no, they never did that.
Right, I'm
I
saying,
don't think they would have lost, I think, but
well,
we never found
it
out.
would have been an effort and they would probably maybe not be here today.
Well, maybe, and they did raise their employee issue at the court below, but they did not pursue that argument on this appeal. I'd like to point out a case to the court that came down recently from the First Department, please. That case is Geiger, Geiger, the Hudson Excess Insurance, 241 NYS 3rd 4. And the pertinent part is at page 11. And I think this is important because what Dryden is asking this court to do is to find that there's been a real sea change in the law, that the 100 years of precedent or so are no longer quite accurate, and that the breach of the duty to defend is no longer a material breach. So I thought that was important because those stem from the First Department. And that case cites Isidore Rosen and Sons, which suggests that it is still good law, and that's in the line of cases that I've been relying upon in my papers. That case from the First Department also says that a stipulated judgment accompanied by a covenant not to execute an assignment of claims can be enforced against an insurer. And it explains that it's not difficult to find justification for the prevailing view when we consider that any scenario wherein an insured is assigning its claims against an insurer to a plaintiff in exchange for a covenant not to execute necessarily takes place when the insured has been abandoned by its insurer. So that's even the First Department, and that's exactly what happened here.
Sounds like.
And counsel, I don't want to put words in your mouth, but it sounds like you're saying that Dryden expressly refused to represent your client in the disclaimers that they sent to your client. And afterwards, that kind of excuses your client from other, because they material breached the contract, and that excused your client to continue to notify them of any notices that they received.
That's correct. It excuses the insured who was on, but yes, that's correct, Your Honor.
Anything else?
Well, I don't understand what bad faith in New York is. I did raise that argument, but I'll rest on my papers on that.
Very good. Thank you so
Thank
much.
you.
Thank you.